He's been medication compliant, but that's what.
Yeah, he is in custody, which is why he's medication compliant. That is the problem. That when he is not in custody, he falls off his medication, decompensates, and attacks women.
So, Your Honor, I'm not excusing Mr. A's past criminal behavior. This itself is different than what he had been subject to. He cannot go back to a shelter like he had been before. Expert was recommending was community-based supportive housing, which the state's own expert testified does exist specifically in the world.
Yes, but he needs something much stricter than just community-based. I mean, come on. Every time he has been let out within months, he attacks someone else, okay? So he clearly needs strict supervision.
Expert credibly testified to, even when he's incarcerated, you would expect to see some sort of proxy behavior, some sort of misbehavior. Mr. A has not had any disciplinary tickets. He has never acted out sexually whatsoever since the incident.
But isn't it a fact that he acts out in front of young children, not necessarily in front of older adults?
That's true that the victims in this case were an age range of 8 to 15. However, as Dr. Fraser, who has extensive experience working with sex offenders, both who have intellectual disabilities and mental illness, she explained what proxy behavior you would see and what she does see in her work, which is that even when there's not maybe children or adolescents, you see behavior like grooming behavior. You see an attempt to
but
watch
there's
TV
no
with
one
children.
to groom. So again, these observations are really difficult because they are in this very structured environment.
It's not the same as probation and parole. He would be subject to 76 conditions that can be specifically tailored. And where the trial court erred is that the trial court had a responsibility per 1007F to consider the conditions of SIST. And when the state, like here, fails to prove that Mr. A has an inability to control sex offending behavior, which means there has to be some evidence that he's...
But they did present evidence that the state's experts did say he has an issue with impulsivity, with his ability to control his sexual desires and how he acts upon them, right?
Problem here, there are two problems here with what respondent's expert was asking the court to do. The first is, again, as we noted, he has already shown, the state has already carried its burden of showing that he meets a certain level of dangerousness and that he cannot be treated purely on an outpatient basis. Based on that evidence, the court correctly concluded that he meets that dangerousness threshold and so has to be placed in a secure facility. Additionally, what respondent's expert was asking for was a level of supervision that went above and beyond what is contemplated by SIST, and that is where we fall into this.
Because what I'm hearing you say, though, this gentleman has an IQ that prevents him from fully understanding that he has to take this medication or he's going to decompensate. Are we saying that he will never get out of confinement?
No,
How does he establish that he has gotten insight? I mean, how does he do that from behind these walls in this setting?